I'm sorry, can you clarify the submission? Can you clarify?
We submit that Sergeant Fuel and Lieutenant White are under the effective control of the Colonel Joy. So there is a failure to prevent or punish the crime. So since knowledge of the crime is established, the superior's obligation is to take necessary and reasonable measures to prevent or to punish the criminal conduct of the subordinate. So in Camp Colonel Joy prevented the killings of soldiers and civilians by ordering that they are not subjected to waterboarding and destruction. So with regard to the in Camp Colonel Joy did not take necessary and reasonable steps to prevent the commission of the crime, and after the killings, he neither took steps to punish Sergeant Fuel and lead the right for the defiance of his order. So, Your Excellencies, Colonel Joy had a duty to prevent and punish his subordinates' criminal conduct, but he failed to perform such duty. So, Your Excellencies, may I proceed to our next submission that Colonel Joy is guilty of intentionally launching an attack in knowledge that such attack will cause the incidental loss or injury to civilians or damage to civilian objects. So the civilian objects are the chemical factories and the associated industries which specialize in metal and plastic products. So let me first establish the ICC elements of the war crime of attacking civilian objects. So the perpetrator directed an attack. So Colonel Joy was in command of the unit that shield the factory in the industrial area of the outland. Second, the object of the attack was a civilian object. So the chemical factories, civilian installations are not military objects because they are not really in support of the military effort for operations. Third, the perpetrator intended such civilian objects to be the object of the attack. So the chemical factories and associated industries were part of the military plan. And fourth, the perpetrator was aware of the factual circumstances that established the existence of the armed conflict. So Colonel Joy, as a commanding officer, ordered the launch of the attack. So, Your Excellencies, it is therefore established that the crime is a war crime of attacking civilian objects. So, we submit that Colonel Joy is guilty of using excessive damage and injury to the civilian. So, protection of civilian in times of armed conflict is fully recognized in international humanitarian law. And deliberate attacks on civilian or civilian objects are prohibited. So, attacks on civilian are considered deliberate if there is knowledge that such will happen in the ordinary course of the event. So the chemical plant is not a valid military target. It is civilian in nature and is therefore a civilian object as defined in additional protocol 1 of the Geneva Convention. So Colonel Joy is aware of it as a civilian object. He knows that the factory contains chemical hazards both to people and environment, and blowing up of the factory resulted to excessive damage on civilians. So, Your Excellencies, Colonel Joy had a duty to protect the environment, but he not only abrogated the said duty, but also violated the very object that a military officer is entitled to protect. So, should you have no further questions, Your Excellencies, may I now see the vote to my co-counsel. May it please confirm.
Please the court. My name is Lloyd Mvi1, co-counsel for the prosecution. Your Excellencies, our learned co-counsel has already discussed with you the charges of indictment. I shall now proceed on a very sensitive issue on whether or not a former employee of the International Committee of the Red Cross or ICRC being called as a witness. The prosecution describes the witness as an eyewitness who was a doctor attending wounded soldiers and civilians at Camp C outland, but performing their official duties, they were beaten and raped by the soldiers of Baseline. Luckily, Dr. Brown survives the inhuman and brutal treatment of Baseline soldiers, disregarding her status being the representative of the ICRC. The prosecution emphasizes that the witness took the initiative to communicate the prosecution and is willing to give evidence before the international tribunal. The prosecution demands to hold the witness as she sees the vitality of calling this particular witness, stating that their testimony is important to prove the guilt of the accused. The prosecution acknowledges the general position adopted by the ICRC that its personnel should not be called upon to testify before courts of law because it would impair its ability to perform its humanitarian role in armed conflicts. However, as a matter of law, the prosecution will not allow the so-called immunity of its personnel from testifying if its refusal to testify to courts of deprive for justice and thus the very reason of such refusal on the part of the ICRC. In the prosecution views, the issues involved therein are, first, whether a third party to the proceedings such as the ICRC is entitled to intervene to prevent a willing witness from testifying. Second, whether the ICRC has the right to determine unilaterally whether the ICRC employees or former employees shall not be allowed to give evidence or testify before the International Court of Justice despite the willingness of such witness. Third, whether or not in the present case, the circumstances are so extreme that the ICRC has a relevant confidentiality interest which can only be protected by not allowing the witness to decode at all. With regard to these three issues, the prosecution strongly argues that the ICRC has no authority in this particular case to inhibit Dr. Brown to testify. The prosecution likewise understands that the national authorities might deny ICRC personnel access to places where persons protected by the Geneva Conventions are located, thinking that these ICRC personnel might subsequently testify in criminal proceedings about what they have seen and heard in those places. Although sympathetic to the ICRC concerns, the prosecution submits that ICRC does not enjoy, in this particular case, as a matter of law, any immunity or privilege that would enable it unilaterally to prevent any of its former employees from testifying. In the present case, it is the victim itself who testified, not being as a personnel of the ICRC, but as a private individual who suffered cruelty with the baseline soldiers of a victim of the rape. The prosecution argued that when baseline soldiers disrespect the ICRC personnel, knowing the real status of being a member of the ICRC, the violations goes beyond not only as a personnel of ICRC, but also to her individual capacity, which the prosecution strongly argued that Dr. Brown is entitled to attain justice as recognized in international human rights. The intervention of ICRC in restraining Dr. Brown to be a witness degrades to achieve justice and its accessibility to protect its personnel or employee, being itself the victim in armed conflicts. The prosecution submits that although ICRC enjoys not to divulge information adherence to its principle of impartiality or neutrality and the rule of confidentiality being recognized as part of the customary law, it does not, however, prevent any of their delegates not to testify in the course of their service to the community. As provided by Rule 96 of Rule Procedure and Evidence of International Criminal Court, which allows ICRC former personnel to testify before the International Court if she is a victim of sexual assault without the need of consent, which is present in this case when Dr. Brown raped by the soldiers of Baseline. And also, In the case of Prosecutor versus CIMIC, I held that as a matter of customary international law, the ICRC enjoys an absolute privilege to withhold its confidential information, providing the ICRC with an absolute right to non-disclosure of information relating to its work. The prosecution submits that the former personnel of ICRC enjoys only the privilege in not providing evidence or to testify, and the court shall regard such privilege and consequently not subject to disclosure, including by way of testimony of any present past official or employees of the ICRC, any information, documents, or other evidence contained into the position in the course or as a consequence of the performance by the ICRC of its functions. So the privilege of immunity from testifying of former personnel of ICRC may be availed only in the exercise of their professional capacity or while performing their duties as a delegate of ICRC. However, there are no provisions in the ICRC policy or in the international customary law that the prohibition extends to those who are victims of sexual assault by the acts of combatants, as in the recent case where Dr. Brown and a Swiss interpreter were raped.
Clarification. It is argued that Dr. Brown, as a member of the ICRC, cannot testify in virtue of the principle of impartiality or neutrality, but can she testify as a victim?
Yes, Your Honor.
Before the International Criminal Court?
Because, Your Honor,
what would be your reasons for it?
Yes, Your Honor, Dr. Brown can testify as a victim before the International Court of Justice because to testify as a witness by the abuses of the soldiers of peace lands, the prosecutions would not ask information related to its work or related to its service which it provides in the country. However, the prosecution would insert information or evidence from here the act of the Eastern soldiers in violating sexual assaults towards her or together with a Swiss interpreter.
Can you cite specific provisions of the law of war itself or Geneva Conventions relating to what happened to Dr. Brown?
Your Honor, Your Excellency, when the Eastern soldiers raped Dr. Brown, it violates the customary laws as recognized by the Geneva Convention that those personnel of the ICRC are protected by the Geneva Convention. However, when the Eastern soldiers raped Dr. Brown, it already violates her right as recognized by the international human rights. It violates her as a person itself, not as a personnel of the ICRC. In addition to that, when the
is that incident or insofar as provisions to the 4 Geneva Conventions, does it fall under Common Article 3? Yes, sir.
pardon me,
Does it fall under Common Article 3 to the 4 Geneva Conventions? Rape of Dr. Brown? Yes, sir.
Yes, Your Honor. Okay, I shall continue your statement. So whether or not ICRC former personnel will be allowed to testify, the authority is given under the court jurisdiction at its discretion to determine whether should be allowed to testify and not the ICRC to mandate the personnel to not to testify. The rule is that the ICRC must consult first with the court with information is deemed by the latter to be of great importance for a particular case. So unless I can give any further assistance or excellencies, that concludes my submissions. Okay. I now cede the podium to my co-counsel as a Mr. Court.